Hey guys, happy Saturday. Anybody got big plans for the 4th of July? I'll be at my brother's watching his dog. So I was gonna go to Kings Island with him, my niece, but they're having trouble finding somebody to watch their dog, Mac. I mean, he could have brought him over to my mom's. She always watches them, but it's just a pain to drive all the way from Columbus here when Kings Island is like on the way. It's closer to his house. Anyway, so I was gonna go with them, and then I decided to just go watch their dog. So I'll be watching their dog on 4th of July all by myself. So, but yeah, and then I was just gonna go because they're only going to Kings Island on the 5th, I think it is, the last day. And then the first 2 days they're gonna be at Great Wolf Lodge going to the water park. I don't like water parks. I mean, I don't do water stuff. So it's like, you know what? Like, then he's like, well, you could just come the one day to Kings Island and we could try to find somebody to watch the dog. But I'm just gonna watch little Mankey and all week. So I'm going Wednesday? Leaving Wednesday. I'll be back Sunday or Monday, probably Monday morning. So I was trying to decide if I'm gonna like do live stream. Oh, this is what I'm gonna try, you guys. I've been wanting to try the vertical lives. So since I have that thing where I have trouble driving on highways without getting tired, but if I'm talking to somebody, I'm fine. Like if somebody's in the car with me or if I'm on the phone, I'm fine. But if I'm by myself, even if I like listen to the radio or watch something or smack my face, like I have trouble, so I have to like pull over and take naps. It sucks. So I'm gonna do a live because I did that the one time. I did a live and it kept me awake because I was just talking to you guys. So I'm gonna do a vertical live. I've never done one of those because it comes up in a different spot. I've been wanting to try it so bad because you get like a whole different audience. Because like if you're just scrolling through shorts, like sometimes I do, like I'll come to these lives that I never would have otherwise seen because they're like as you're scrolling, they'll pop up. So you get like new people, people that normally would never even have heard of you. So I've been wanting to try it. So I'm gonna try it. I'm gonna try it. So I've been trying to think, should I do it facing the road like I did last time or facing me? I kind of want to face the road. So on my drive though, so I'm gonna do that. So you guys, either Wednesday morning, probably. No, it'll be Wednesday late afternoon or maybe early evening. Look out for the vertical lives because I don't know how they come recommended. I don't know if it like recommends the same way, but I'll try to remember to do a post so you guys could come in case if you don't get recommended. Yeah, but your names are what? I don't know what you mean names are different. I don't see anybody. Is names different? Oh, they are. It's showing up. Wow. Now it's showing up as it does in comments, which I never got that because in comments it shows different than in live chat. You think it would be the same. Now it's showing up as what it shows up in comments, like your tag or whatever it is. Okay. Normally it shows up as your, I don't know why there's two different things, but that's what's happening. Huh. Hey, Kim, what's up? Was your last? Yeah, it was a couple days ago. Yep. Yep. At your ats. Wonder why they changed that. Like I said, I never did understand why it wasn't the same. It's like you comment under one name and then on live chats, it's a different name. So it kind of does make sense that now they're the same, to be honest. But I wonder like what made him change it. Yeah, that'd be cool if it did though, Ausane. Ausane, did you get my text? I just well, I'm sure you did. I just texted you that I was gonna be going live. Um, anyway, hey Candy, and let me say hi to a couple people and then I'll start, guys. Guess what I got though today, which I wasn't expecting to get it until I got back. I got the phone calls. Um, so this is what I'm thinking. Either when I go to my brother's, I was debating because I'm not gonna have to all my equipment to do like big edits or like streams where I mean, so what I was gonna do if I didn't get it, I was gonna continue doing the kiosk reading the messages because that would be easy to do on my laptop and stuff. I wouldn't have to have like 2 screens for that. You know what I'm saying? I'm trying to find something that's just like one thing, easy to do just with one screen. Or maybe I could try to, edit some, like, pre-records for the, phone calls. I've been listening to them today. I'll tell you a little bit more about them at the end because I do wanna start on these. So, anyway, yeah, some new documents came out a couple days ago. And I think a lot of people went over them yesterday or the day before. I'm a little bit late to the game, but who cares? I'm gonna read them. Uh and I've seen a lot of people, they don't like read the whole things, which is fine. I like reading the whole things. It gives me something to do. Some people probably do. The videos I came across that got recommended, they were just like reading like highlights. So I'm like, I'm gonna read the whole thing. And it's interesting, you guys. It's actually interesting documents. I'm always looking at the new documents, and a lot of it's just like boring or real short stuff that's nothing new. So when there is like something that actually has some new stuff that kind of tells us a little bit about the case that we don't know about, or a little bit about a side of what they're going for and stuff. It's interesting. So it's like I got to read these. So it's for the Idaho case, guys. So hold on, let me get you a date exactly when they came out. Let me go. Hold on. Anyway, how's everybody doing? What are your guys' plans? Real quick while I'm getting that for fourth. Okay. So they came out up on the site on the 26th. So, well, some on the 2 on the 25th and 2. Well, which ones am I reading though? Well, I'm only reading 2 documents. I forget what the titled. Hold on. You hear that music? There's somebody having a party next door or like a couple doors down. And okay, the 2 that I'm reading came out the 26th. So it came out 2 days ago. So on Thursday they so I'm not too late. Okay, I don't know what time. It could have been later Thursday. I'm not sure. All right, guys. Let me see what you guys are doing now. I know. You guys hear that? They have a band at their house. We've been hearing the music all day. It's like like my mom's like, I think it's somebody's 40th birthday party. I don't know why she thinks that. Um, and they actually have a. Do you hear it or no? I'm curious. What you? 'Cause sometimes you guys could hear like sensitive and sometimes not. I know with my other microphone, you guys never heard like the fireworks or anything. I don't know if this one's different. Anyway, it's not really that loud. I'm just curious if you guys hear it. Okay. Oh, Lisa, I gotta do your Cash App. Shoot, I don't. Yes, I didn't feel yesterday. Oh my god. I'll talk about that later too, so I could get started. But okay, good. No. Hey, have me. Okay, put a 1 if you guys have already read these documents and a 2 if not. You know how I like to do it. I like to know. I like to know. All right, let me put you over here. And yeah, put a 1 if you've read them and a 2 if not. Okay, good. Bon appetit, Diana, Suzanne, James, Melanie, Deb, Austin, Kim, Lisa, Ella Blow, Ella B10. What does that say? Ella Blow. Milazima. Oh my god, I just realized these names are gonna be harder because they're gonna be longer and more like not as like they're just gonna be different to read and write out. Oh my god, that's gonna be annoying to write it out to if you want to tag somebody exactly. All right, so let's do it. 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 Share screen. partying it up, dude. They you know, I have fun. I don't know what I'm talking about. Being silly. Okay, I'm just trying to exit out some of these screens. Okay, now we got them narrowed down. All right, let's do this. I might do another live on Travis Decker. There's some documents that I've had for like 2 weeks now that I wanted to share. And then I've been like every day I've been looking into what's going on and collecting like screenshots and different if there's any updates, which there's not a ton. For like everyday checking for new stuff. Like I don't have that much stuff because it's just I think that's why I kept putting it off till I got a little bit more things because there's just not much going on. But I do have that I would like to maybe do an update on. Okay. So these are the 2. There are like 6 or 7 documents that came out. The other ones are like a page long or these are the 2 I'm choosing to read. They're interesting. They have like hints of like new like things that we didn't know because you know how it's been hush hush. Like everything is so quiet about this case. Kind of reminds me of the Delphi case. The Delphi case, we barely knew anything until that Frank's memorandum came out. And that only came out because the defense filed it and was able to put things in there because of, you know, what he was arguing. So, yeah, I love when there's stuff that adds new things. Okay, let me take a sip of this real quick. Man, I didn't warm it up hot enough. I'm drinking decaf. Caffeine has been making me jittery lately, guys. I've not been liking it. I can't handle it right now for some reason. Okay, here we go. So, redact a memorandum, decision in order on defendant's motion to continue. Before the court is defendant's motion to continue the trial in this matter. The basis for the motion is threefold. First, he asserts that the volume of discovery continues to pose a challenge to his counsel's ability to timely and meaningfully review all of it. Second, he asserts that there's a penalty phase investigation and preparation that still needs to be done. Third, he asserts that recent and forthcoming publicity on the case is highly prejudicial. Maintaining the current trial setting under these circumstances, he argues, will render any conviction and sentence unconstitutional. The state responds that defendant's motion is untimely and has failed to show either good cause for continuing the trial or prejudice that would result from maintaining the current trial setting. Um, Oral argument on the motion was held on June 18th, 2025, after which the court took the matter under advisement. The court finds a continuance is not warranted as defendant has not made a showing that there is good cause to continue the trial or that his substantial rights will be prejudiced by proceeding the trial as scheduled. Um, just crazy because think about it. The one point that they make that saying that about um where is it? That the recent forthcoming publicity on this case is highly prejudicial. Well, the longer they wait, the more publicity is going to be out, the more stories are going to be out, the more things are going to be out, the more documentaries and more stuff. So it like makes that part makes no sense. So why, okay, let's just keep putting it off and have chances that the potential jurors are going to have more things that to be exposed and more of a chance to be exposed. That makes absolutely no sense. That should be an argument. Let's hurry this up so we can find a just jury that's not exposed to stuff. You know what I'm saying? So that is stupid. I'm sorry. That part. I know there's more to it than just that, but I mean that right there. Anyway, standard. A motion for continuance of a trial is addressed to the sound discretion of the trial court. On discretionary matters, the trial court must correctly perceive the issue as one of discretion, act within the outer boundaries of its discretion, act consistently with the legal standards applicable to the specific choice available to it, reach its decision by the exercise of reason. Lunenburg versus My Fun Life. Okay. Analysis. Under Idaho law, a criminal defendant seeking a continuance of trial must demonstrate that his or her substantial rights will be prejudiced absent a continuance, unless an appellant shows that his or her substantial rights have been prejudiced by reason of a denial of his or her motion for continuance. Appellate courts can only conclude that there's no abuse of discretion. Trial judges necessarily required a great deal of latitude in scheduling trials. The burden of assembling the witnesses, lawyers, and jurors at the place and time for trial counsels against continuances except for compelling reasons. There are no mechanical tests for deciding when a denial of a continuance is so arbitrary as to violate due process. The answer must be found in the circumstances present in every case, particularly in the reasons presented to the trial judge at the time the request is denied. Where a continuance is sought based on the late disclosure of discovery of evidence, the alleged tardiness. Where a continuance is sought based on the late disclosure. Why did that pop up? That's so weird. You know how your phone will sometimes, like, a video will pop up, like it's on a lock screen, but have you ever had that happen where, like, it'll just start, a video will start playing out of nowhere? I don't know why it does that, but my video just started playing because I was chatting in there when I was warming my coffee. That's weird though. I still don't understand why it does that sometimes. Let me exit out everything. Okay. Scared me hearing my own voice. Anyway, where a continuance is sought based on the late discovery or evidence or discovery of evidence, the alleged tardiness of the discovery must be shown to prejudice the defendant's case preparation that a fair trial will be denied. The bare claim that the bare claim that additional investigation could have been conducted is not sufficient to demonstrate unfair prejudice so as to support a motion for continuance. Additionally, where a continuance is sought for the potential receipt of evidence from further investigation, the motion is properly denied if it's based on speculation, which you'll see some of this speculation. Okay. Defendant argues a continuance is necessary for him to sufficiently review relevant discovery, conduct a full and complete investigation of mitigation evidence, particularly claimed newly revealed evidence that allegedly raises red flags, and remedy the prejudice caused by recent and upcoming inflammatory publicity and the alleged leak of information to the media. Moving forward with trial, he warns, will violate his rights under the United States and Idaho constitutions to due process, to be free from cruel and unusual punishment, to a fair trial, to effective assistance of counsel, to present a defense and confront witnesses, and to a fair and reliable sentencing determination. Absent from defendant's materials, however, is any good cause for the continuance or legitimate showing of prejudice should the trial proceed as scheduled. So they're saying, like, they're not showing any good cause for continuance or legitimate showing of any prejudice should the trial proceed as scheduled, which I agree. I do. I know some people probably don't. Defendant has not demonstrated a continuance is warranted to review discovery. Defendant first contends that the vast amount of discovery in this case renders it impossible for the defense team to review the necessary and relevant discovery in a manner that allows for it to be comprehensively integrated into his defense. He further argues, without any support or explanation, that there are a myriad of issues that continue to arise from the state failing to comply with discovery and expert disclosure deadlines. A continuance, he argues, is necessary for counsel to mount an effective defense. The court, however, rejected the same argument 2 months ago when defendant sought to strike the death penalty and impose discovery obligations upon the state. In its order, the court observed the utter lack of any proof supporting defendant's accusations of discovery violations by the state. More importantly, the court found defendants' complaints of being unable to meaningfully review discovery entirely unconvincing, pointing out that counsel struggled to articulate in any meaningful way what evidence, let alone relevant evidence, counsel had been unable to review over the past 2+ years, and why efforts to facilitate discovery review were not made long ago through this court. Wait, I want to read that again. Hold on. Counsel had been unable to review over the past 2+ years, and why efforts to facilitate discovery review were not made long ago through this court and or resource judge. Okay. I don't know if I should read these. Sometimes it's just not, it like breaks it up and I'm gonna wait to read the notes. Anyway, defendant's second round of this argument fares no better. He again fails to identify any relevant discovery that his counsel has yet to review. He also fails to identify any steps his counsel has taken, particularly since the court's prior order to aid in processing the yet unreviewed discovery. Moreover, he does not explain why he waited to seek continuance until after discovery closed. Expert disclosure deadlines passed and the pretrial conference occurred. If the defense counsel was truly struggling with discovery review, this motion should have been made when the claimed problem became apparent, and certainly should have been brought prior to the expiration of discovery. All expert deadlines in the final pretrial conference, so it should be made prior to all of that. Instead, defense counsel has robustly litigated the case, retaining approximately 24 experts and a full mitigation team, engaging in an extensive motion practice and disclosing witness and exhibits lists with nary a whisper that a continuance would be sought. These actions belie his counsel's ongoing and ultimately empty discovery complaints. Without more, the court can only conclude that defense counsel is using the volume of discovery measured in terabytes as a tactic to delay the proceeding at the 11th hour simply for the sake of delay rather than a legitimate threat of prejudice to defendant's substantial rights. Perhaps even more problematic and more telling is the utter failure of defense counsel now or at any time to specify not only what needs to be reviewed, but importantly, when that review would be complete and defendant ready for trial. Instead, defendant seeks an unbounded continuance with no apparent plan to complete the review or unspecified evidence that counsel claims it has yet to review. This is not sufficient to warrant a continuance. Agree. B, defendant has not established a continuance is necessary to conduct a more thorough life history, investigation, and identify necessary experts. So they're saying he has not established a continuance is necessary to conduct a more thorough life history, investigation, and identify necessary experts. Because you'll see some of the list of what they need to do or wanted to do or whatever. Anyway. Defendant next argues he needs additional time to investigate and prepare mitigation evidence, which he contends is necessary to uphold his constitutional rights, particularly those under the 8th and 6th Amendments. Specifically, the defense team claims that to be effective, counsel must conduct an exhaustive and comprehensive dive into the defendant's life history for additional mitigation evidence, analyze the information into a cohesive narrative for the jury, and identify any additional behavioral, cultural, scientific, and or health experts that may be necessary to develop the mitigation presentation. Move this a little bit closer here. Despite having hired a mitigation team 2 years ago, defense counsel contends that recently discovered, and there's a lot of these redactions at places that I wish it wasn't redacted. I would love to know what was redacted, what it said, but anyway, have raised red flags that defendant may have redactions. According to defendant's primary mitigation investigator, Attorney redacted, her team of 4 have been diligent in their investigation into defendant's life history. But there have been some redactions. I mean, she believes that with time, she will be able to overcome these barriers by, and then more redacted. Defendant has not demonstrated a continuance to accommodate further investigation is constitutionally required. The Eighth Amendment requires that a capital defendant be allowed to present all relevant evidence in mitigation. Jury must be allowed to consider all of capital defendant's mitigating character evidence. In addition, a capital defendant has a Sixth Amendment right to a fair trial and effective assistance of counsel in both guilt and penalty phases of a capital case. As defendants point out, defense counsel is constitutionally required to conduct a thorough investigation and preparation for the penalty phase of a capital case. Presentation of some mitigating evidence, even if strong, is insufficient if other mitigating evidence is available upon reasonable investigation. The assertion that counsel needs the continuance to conduct an exhaustive and comprehensive dive into the defendant's life history for additional mitigation evidence overstates the extent of his counsel's constitutional obligations. Counsel's investigation into mitigation evidence must be reasonable. The Idaho Supreme Court and the United States Supreme Court hold that defense counsel is not required to investigate a defendant's entire life in order to present constitutionally sufficient mitigation evidence. Because you should see the list, how far they want to go back, and like what I think it was like fourth grade and like really far back. So, like, yeah, if you have time to do it, do it, but you're not going to get a continuance to try to get his whole entire life history. That's just not reasonable. Anyway, it says, we emphasize that Strickland does not require counsel to investigate every conceivable line of mitigating evidence, no matter how unlikely the effort would be to assist the defendant at sentencing. While defendants notes that the ABA guidelines for mitigation function of defense teams in death penalty cases urge counsel in death penalty cases to conduct an ongoing, exhaustive, and independent investigation of every aspect of the client's character, history, records, and any circumstances of the offense to meet their constitutional obligations, courts look not to what is prudent or appropriate, but only what is constitutionally compelled. Rejecting that heightened procedural safeguards should be employed at discovery in capital cases. Roe, a capital case, is instructive here. On post-conviction, Roe argued her counsel was deficient because they failed to perform an adequate investigation into Roe's background in search of mitigating evidence. Specifically, Roe argued counsel should have investigated her life from birth to the sentencing hearing, that counsel were deficient in presenting her mental health workup. The court rejected this claim, holding that counsel was not required to investigate Roe's entire life in order to objectively and reasonably present Roe's mitigation evidence. The court further noted the great lengths counsel underwent to investigate and present mitigating evidence from several of Roe's friends, health and welfare records, letters from friends and family, and Veterans Administration records concerning Roe's husband's previous injuries in the couple's relationship. The investigation defendant's experts have undertaken over the past 2+ years far exceeds that in the Roe, and in fact readily appears to satisfy the relevant ABA guidelines cited by defendant. It includes, but is not limited to. Now, this is an interesting part here. I feel like this list, so that we see what some of the stuff that they are have for Brian. Okay. Defendant's PhD education records, including coursework, interviews, and correspondence. Defendant's mental health and medical records, including as a redaction, and then, redaction. Records related to a childhood car accident. Defendant's employment records, mental health, education, and employment records of defendant's sisters, which I don't know if that's really something that Mental health records of defendants' parents, father's military records, and social security records. I mean, they are getting way more than what they would need. You know what I'm saying? Like, I think court records from multiple generations of Kohberger family, paternal side, VA records and death certificates from maternal and paternal uncles, multiple interviews with defendant and each immediate family member, um, interviews of two of defendant's fourth grade teachers, former boxing coach, and psychologist who evaluated defendant in 2005. So wait, in 2005, that was 20 years ago. Yeah, they are going back pretty far. So I think I mean, you know what I'm saying? That's fine if that's what they want to do, but they even want more than this. Interviews with multiple members of defendant's extended family on maternal and paternal side. Now, I know they said that some of this stuff maybe isn't done yet. It appears to, let's see, to undertake it. Yeah, it seems like they have done this already, right? Or maybe they're still working on some of it. But anyway, okay, sorry. So interviews with multiple members of defendant's extended family on maternal and paternal side, interviews with the defendant's professor and advisor at DeSales University, interviews of defendant's former coworker, interviews of at least one family friend, and letters and jail calls between defendant and his family. That's going to be good. Dude, I hope they like allow all this to like I hope here's the thing, I hope when we watch the trial that they when they play these exhibits, if they do play this, I hope it's one of those ones where they actually play it on the video because sometimes they don't show everything that they show in court. Hopefully they do. Okay. It is evident from the reports of defendants mitigation experts, Dr. Orr, Dr. Ryan, and Dr. Brams, that they have developed an expansive understanding of defendant's family. Family, environment, social development history, family history, both nuclear and extended over multiple generations, educational history, and mental health and medical history. From this evidence, these experts have rendered several current diagnoses and identified other diagnoses for which defendant met criteria at some point in his life. Despite such an extensive investigation, defendant claims additional investigation is warranted to identify redaction and redaction. So one's redacted, two's redacted, and then it says, however, defendant has not established that such investigation is constitutionally compelled, particularly given the existent or the extensive work already completed. Rather, the claimed need is based on unqualified speculation by redaction. Defendant has not offered any declaration by any of his disclosed mitigation experts opining the same. Nor has he pointed to anything in their expert reports that would support blank speculation. As noted, a continuance of trial is not warranted to chase down mere speculation that potential evidence exists. Further, defendant has not set forth a plan for continued investigation. How much time it will take, what his team expects the investigation will reveal, why it is necessary to uphold his constitutional rights, and why these matters are only now being raised with the court. Additionally, assuming guilt is found, the penalty phase of the case will not begin until late October or early November. Thus, there remains significant time for redaction or blank and her team to continue their investigation and to supplement expert disclosures if warranted. One, there's some redaction, and it says speculation that defendant redacted is simply that speculation built on circumstantial evidence, and a bunch redacted, even a little footnote redacted. So this is continuing from this that's redacted because look, but anyway. So conditions which are currently attributed by his own mitigation experts to his ASD, OCD, and or ADHD are consistent with childhood trauma, and there is evidence of poverty, both generational and familial. According to a bunch redacted, like a paragraph redacted, notably missing from redacted's declaration is any indication as to how she intends to confirm her suspicions or how long she expects it to take, be that months, years, or even decades. So they're not even like they say, oh, we want a continuance, but they're not saying like, how long do you think it's going to take? How long do you need it for? Can't just have like a forever continuance until you decide you're ready. Defendant has been subjected to multiple lengthy interviews by several different experts over the past 2 years. Based on that, expert reports reviewed by this court, redaction, and then it says defendant's family has likewise been extensively interviewed, and there has been, so so they have it labeled at 14, 15. So like a 4 paragraphs or almost 4 paragraphs redacted. And this continues to this redacted report, but it says been no report that redacted. None of defendants redacted have raised the alarm that I'll just say blank because I feel like when I say redacted, it might, I don't know. What do you guys prefer? So it has it raised the alarm that blank, despite having the same information blank relies upon, and then there's a few sentences, half a paragraph and a half redacted. And then it says, instead, it is an invitation for a perpetual continuance. More importantly, aside from the redacted, all of this information has been available and documented in the record for months. Yet again, that defendant is only now moving for a continuance for further investigation into blank, unsupported suspicions, smacks of tactical gamesmanship, and delay. Absent more compelling evidence that redactions, and it says plan for, and then another footnotes redacted. It looks like a whole paragraph, almost a whole paragraph redacted, uncovering it in a reasonable timeline to do so. There's no constitutional basis for further investigation, particularly on an open-ended basis with no plan to bring the matter home. Redaction. Counsel's argument that more time is needed to investigate whether redacted, likewise squarely unsupported, another bunch redacted. Defendant has never moved for an extension to his disclosure deadline for penalty phase experts so as to allow further opinions in this regard. Nevertheless, redacted, who again is not even marginally qualified to opine, some redactions, and then it says believes that there's evidence that redacted and seeks additional time to unearth it. Her support, which has not provided to the court, redaction, again, not one of defendant's redaction experts who have had the same information redacted has identified, so blank has identified, has submitted a declaration stating that they may change their diagnosis based on further investigation, blank. Rather, it is based on blank speculation that further investigation might change blank. Such speculation is not grounds for a continuance. And then there's a bunch redacted again, a couple paragraphs. It says not only is there a lack of support in the record for blank anticipation that more investigation into blank to change their minds, blank and her team and defense counsel have known since November of 2024 that redactions, neither the defense team nor blank have articulated what efforts they have made, if any, since that time to understand the basis of blank. Further, they have not indicated what plan they have to obtain this information if a continuance is granted or how long it will take. And then we got a sentence redacted. Says in sum, defendant has not demonstrated that a continuance for further investigation and potential mitigation evidence is necessary. to uphold his constitutional rights. The right to present mitigation evidence and the right to effective assistance of counsel do not necessitate an investigation of his entire history. They simply require that the investigation be reasonable. While easily available, mitigation evidence cannot be ignored. Defendants' briefing demonstrates that the evidence they are attempted to obtain is far from easily available, and in fact, they may not even exist. Further, the evidence prompting the need for further investigation has blank been available for months, yet it is only now that the defendant seeks a continuance. This tactic seems geared toward achieving delay rather than a good faith effort to obtain meaningful mitigation evidence. Moreover, the defendant provides absolutely no plan for how further investigation will proceed, who will be interviewed, or how long will it take. The Constitution does not demand, and this court is not willing to continue the trial indefinitely to allow the defense team to embark on a fishing expedition, pulling at every conceivable thread in defendant's familial tapestry. Do you hear that? Oh, it was like a dee. It went away. Counsel's assertion that they will be better prepared with more time and more evidence is an assertion shared by every lawyer involved in a trial. At some point, and particularly after 2.5 years of investigation, the defense team must be satisfied with what they have, which in this case is extensive. In addition, while the crime victim's rights to a timely disposition under Article 1 do not trump defendants' federal constitutional rights, they provide an additional justification for proceeding with trial as scheduled. For these reasons, a continuance is not warranted. A continuance is not warranted due to pretrial publicity. So now they're going to explain this. Defendants next seeks a continuance due to a recent inflammatory pretrial publicity. On May 9th, 2025, approximately 3 months before trial is set to begin, Dateline NBC aired a 2-hour episode about this case. The episode included details and materials about the case, which, if are true, are not publicly available, and which promote a narrative of guilt. Defendant also advises that on July 9th, 2025, Amazon Prime Video is planning to release a 4-part docuseries about the homicides. Ooh, I got to remember that's going to be good. Man, I wish that was coming out when I met my brothers. That'd be a perfect time to just sit back and watch because I'll need things to fill the time. Anyway, so a 4-part docuseries about the homicides. And on July 14th, crime author James Patterson is set to release a book he wrote about the same. Defendant contends that this media coverage so close to trial threatens his right to a fair trial by an impartial jury. But the longer they wait for a chance for people to see these, the more people are going to see them. So what? Wait so more people have the time to see them? Or do it when there's going to be less people? You know what I'm saying? If you do it in August compared to like waiting like a year, that's going to give how many more people a chance to watch that haven't seen it yet? Anyway, where are we at? So it says that threatens his right to a fair trial by an impartial jury, which can only be ameliorated, I don't know how to say that word, by a continuance. No, that's not true. In addition, defendant argues that a continuance is necessary to investigate the source of the leaks to the media and impose accountability. The court does not agree that either argument compels a continuance. Defendant's right to a fair trial is not denied by the pretrial publicity, which is not likely to subside with time. Sixth Amendment to the U.S. Constitution affords all criminal defendants the fundamental right to a fair trial. This includes the right to have impartial jurors who know as little as possible of the case, decide the defendant's guilt based on material admitted into evidence before them in a court proceeding, uninfluenced by extrajudicial statements. A trial has an affirmative duty to minimize the effects of pretrial publicity. In Shepard, relied upon by the defendant, the United States Supreme Court recognized the adverse effect inflammatory publicity has on the ability to obtain an impartial jury, and strongly urged trial courts to act quickly and forcefully in addressing such publicity. The court further advised that where there is a reasonable likelihood that prejudicial news prior to trial will prevent a fair trial, the judge should continue the case until the threat abates or transfer it to another county, not so permeated with publicity. The statement from Shepard, however, must be read in context. The media coverage in that case is far different from that present here. In Shepard, news reporters extensively covered the story of Sam Shepard, who is accused of bludgeoning his pregnant wife to death. The court examined the extensive media fanfare surrounding the case, noting, let me make sure I should check back with chat just to make sure everything real quick. Okay. Shepard was not granted a change of venue to a locale away from where the publicity originated, nor was his jury sequestered. For months, the virulent publicity about Shepard and the murder has made the case notorious. Charges and countercharges were aired in the news media besides those for which Shepard was called to trial. In addition, only 3 months before trial, Shepard was examined for more than 5 hours without counsel during a 3-day inquest, which ended in a public brawl. The inquest was televised live from a high school gymnasium seating hundreds of people. Furthermore, the trial began 2 weeks before a hotly contested election, at which both Chief Prosecutor Mahone and Judge Blythen were candidates for judgeships. The court found that there was no doubt that this deluge of publicity reached at least some of the jury, given that when the jury was questioned for the only time, 2 jurors admitted in open court to hearing the highly inflammatory charge that a prison inmate claimed Shepard was the father of her illegitimate child. Nevertheless, the trial judge rejected requests by defense counsel for the jurors to be asked whether they had read or heard specific prejudicial comment about the case. Wait, so that was the trial judge rejected a request by defense counsel for the jurors to be okay. Further, the jurors were subjected to newspaper, radio, and television coverage of the trial while not taking part in the proceedings. And were allowed to go their separate ways outside of the courtroom without adequate directions not to read or listen to anything concerning the case. Wow. That's crazy, actually, really. Intervals during the trial. The judge gave suggestions and requests to the jurors at intervals during the trial to refrain from commenting upon the case. But the jurors were thrust into the role of celebrities by the judge's failure to insulate them from reporters and photographers. Bedlam reigned at the courthouse during the trial, and the newsmen took over practically the entire courtroom. Wow. The court reversed Shepard's murder conviction. Crucially, the court stated that although the pretrial publicity alone was not sufficient to warrant relief, when combined with the carnival atmosphere the press created at trial and the judge's inability or lack of desire to control courtroom proceedings, Shepard's right to a fair trial was denied. Yeah, that's crazy. I can't believe that happened. Pretrial publicity, even pervasive, adverse publicity, does not inevitably lead to an unfair trial. Gosh, this is getting glitchy. Okay. If months virulent pretrial of media coverage was not enough to deny due process, and Shepard, it is certainly not enough in this case, where the media coverage has been far less pervasive. In addition, this court is employing the measures recommended in Shepard to protect a defendant from prejudicial pretrial publicity, to wit, limiting the number of reporters in the courtroom during trial, insulating prospective witnesses from interviews with the media about their prospective testimony, and making an effort to control the release of leads, information, and gossip to the press by police officers, um, witnesses, and the counsel for both sides, to avoid the disclosure of inaccurate or inadmissible information to the public. Ultimately, whether a defendant can receive a fair trial depends on whether a fair and impartial jury can be seated. As the United States Supreme Court has said, to hold that the mere existence of any preconceived notion as to the guilt or innocence of an accused without more is sufficient to rebut the presumption of a prospective juror's impartiality would be to establish an impossible standard. It is sufficient if the juror can lay aside his impression or opinion and render a verdict based on evidence presented in court. Now, but I do think using that Shepherd as a example is saying like, look, like they didn't rule there on that. That was messed up. They should have, I mean, they should have had more control over that. So I don't like that they use that as like a comparison, because that I'd be mad if I was, oh shoot, if I was that person. Well, I never murder anybody, but you know what I'm saying? Nowadays, I feel like they would never allow that crap. This isn't even anything. The thing is, this isn't even anything compared to that. That's why I don't even understand why they compare it to that. At least I hope not. I'm saying, like, when I say compared to that, I'm not saying like the case. I'm saying that the judge wouldn't be that uh what's the word? Like neglectful. No, not neglect. I can't think of the word, but he wouldn't be like that. I'm sure he's going to sequester them and he's going to make sure they don't talk outside, make sure or outside of the jury, like don't talk about it, don't watch anything, don't do interviews. He'll protect the identity of them. So that's what I'm saying. Of course they're going to do all that, I would hope. So that's not even comparable. Like, you guys following me? I don't even understand. I wish they wouldn't compared it because that makes it look bad. I mean, it's not going to be the same. The judge, I hope the judge wouldn't do that to them. I couldn't see any trial judge doing that these days, right? What year was that? Shepherd one. I don't know. Did you catch a year? It had to be a while ago because that's crazy. I've never seen that since I've been watching trials. I don't know. Sorry, I'll continue. Okay. Where do we do it? Where did I leave off? Here I can't find. Oh, I think right here, right? The impression, opinion, render a based on evidence presented. Yeah. Accordingly, the Idaho Supreme Court has long recognized that trial courts can successfully select an impartial jury despite widespread publicity. In State versus Federally, a capital case, the Idaho Supreme Court disagreed with the defendant's claim that extensive publicity prior to trial deprived him of the opportunity to be tried before an impartial jury, because each juror was extensively questioned to determine the degree of their exposure to the pretrial publicity. The court found the defendant's rights were preserved. In the defendant's subsequent habeas case, the Ninth Circuit examined at length the entire voir dire. um, Hi, oh, best to me. It's so weird seeing different names because sometimes the names are so different that I might not know at first who's who. Best to me, what is your normal name? All right, sorry, where are we at? Blah, 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 da, da, state. Da, 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 da. Disagree with the defense claim extensive. Where at? Defense claimed that extensive publicity prior to the trial deprived him the opportunity to be tried before an impartial. Oh, because they were extensively questioned. Okay. Uh, it says the ninth examined a length of, oh, that's right, and found no prejudice, even though on the day of jury selection, the case was covered on the front page of the local newspaper as well as on TV and the radio. With the measures the court has already put in place to protect defendant against the pretrial media coverage and the court's carefully crafted jury selection process, there is no reason to think that an impartial jury cannot be selected through a searching and robust voir dire. Man, I can't say that very good. Certain words I can't say. Good. In addition, while continuances may be appropriate if pretrial scrutiny is reasonably expected to fade with time. No, that wouldn't happen with this one. It is an ineffective tool where publicity is such that there is no reason anticipate that it would subside by any delay which would not put off the trial indefinitely. In United States versus Marino Morales, the Court of Appeals for the First Circuit noted the denial of a motion for an indefinite or substantial continuance predicated upon widespread adverse pretrial publicity about a defendant is all the more warranted when, as here, there is sound reason to believe that the defendant will continue to be controversial, publicity invoking figure. Oh, my God, can't even say those words together. Publicity invoking figure, and hence that there is a little assurance that the passage of time will result in an abatement of subsidence of critical publicity in the foreseeable future. Mouthful. The court observed the Sixth Amendment's guarantee of speedy trial is one to which the government and society, as well as the accused, has a claim. And they stated that society cannot be utterly deprived of the right to prosecute and to try someone for a crime within the reasonable time merely because of widespread community knowledge. And then it talks about Gilday versus Callahan denying the continuance upon finding no reason the intense public interest in the case would abate, concluding that where pretrial publicity and heated public opinion was ongoing, there was no reasonable hope that it would fade with continuance. Here, there's no assurance that the pretrial publicity will fade with time. The murders occurred over 2.5 years ago. The circumstances of the murders were provocative for college students in a small Idaho college town were brutally stabbed to death by an unknown perpetrator. It was an immediate media sensation and garnered widespread attention that not only continues to persist, but continues to grow. 18 months ago, defendant moved for a change of venue from Latah County, due in part to the extensive inflammatory pretrial publicity and the allegations made by Mr. Kohberger to the public by media made about, sorry, let me correct that. Allegations made about Mr. Kohberger to the public by media that will be inadmissible at trial. For change. What does the MTN stand for? For change of venue. Motion for change of venue. He argued that Latah County was not large enough to avoid the bias caused by the pervasive prejudicial publicity. Defendant's motion was granted, and as a result, the trial date was continued by approximately 10 weeks. Those additional 10 weeks have not resulted in fading media attention. It has only given the media more time and opportunity to provide coverage to a public audience which is clamoring for answers. The longer the public is made to sit and wait for the facts to come out at trial, the more time there is for inflammatory speculative stories, movies, and books to circulate, and more time for prior ones to be rebroadcast, purchased, viewed, and consumed by the public. Proceeding with trial as scheduled will likely avoid negative consequences from future publicity. Thus, the court finds a continuance, if not warranted, based on the medial coverage. Rather, careful and patient voir dire is prescribed. Trying to figure out what song it is. Okay. It's raining men. That's what's they're playing. It's raining men. There's a band. If you guys are just coming in at my neighbors, they're having some kind of party, but we don't know them. It's like not right neighbors. It's like down the road, but like since our back of our houses are like the way it is, it's like diagonal, so it's closer. But like on roadwise, it's I don't know. Anyway, um, okay. A continuance is not warranted to investigate the leak of information. That's true. Defendant also asserts that a continuance is necessary to accommodate the special prosecutor's investigation into the source of the leaks to the media and to impose accountability. With regard to the Dateline episode, defendants points out that the Dateline represented that the material came from sources close to the investigation. He notes that Patterson's upcoming book on the crime promises claims to be the most comprehensive narrative of the investigation and evidence to date, and is based on 300 interviews, several individuals, including the victims' families and local law enforcement. He also notes that Amazon Prime docuseries promises to be told in captivating, tense, and emotionally wrenching detail by only those involved in the affected by the crime. He argues that if any of the leaks came from the witness if any of the leaks came from witnesses the state intends to call or from others involved in the investigation, the information is Brady material because it would serve to impeach the leaker's credibility and may be exculpatory in nature. He adds that if the investigation reveals that the other state agents had information about the leaks but failed to disclose it, this omission would constitute a Brady violation. As noted, a continuance is not warranted where the information sought thereby is mere speculation. Roe, defendant's Brady argument is built on a house of speculative assumptions. An assumption that there was a leak by persons bound by the non-dissemination order, an assumption the leakers will be found, an assumption that the leakers were law enforcement, an assumption that the leakers or others who maybe were complicit will be testifying as a government witness, and the assumption that these witnesses will likely be material. Such assumptions are not grounds for a continuance, particularly given that there is no guarantee if and when they will be confirmed or debunked. This trial cannot be held hostage indefinitely to the outcome of the investigation, particularly given the very significant chance the leaker may never be discovered. Thus, the court will not continue the trial pending the results of an investigation based on speculation that it will be successful in the hope that impeachment evidence may be uncovered as a result. Bam! Okay. Oh, let me take a sip of my coffee. Okay. Saying, are you number one still? Who else? Hey, Melazima, who are you? Wait, oh my God, your picture. I forget. What is your original name? I should know this. Hey, Hope. This is Hope G, right? I don't know. I kind of don't like it because I'm used to having the other names, plus they're shorter to tag people. Okay, you guys ready for part 2 or the next document? Let's get her done. This one's only 7 pages. Okay. So, redacted order on defendant's offer of proof of alternative perpetrators. Introduction. The state previously moved in limine seeking to preclude defendant from offering or arguing alternative perpetrator evidence without first satisfying the applicable evidentiary standards. Well, yeah. They have to satisfy the standards, right? In accordance with the court's subsequent order on the motion, defendant filed his offers of proof and evidence in support, identifying 4 individuals as potential alternate perpetrators. The state objects to the presentation of this evidence at trial, arguing it fails to satisfy the standard under State versus Meister. Defendant conceded at oral argument that at this point, his proffer is not sufficient to pursue an alternate perpetrator theory at the outset of trial, but requests latitude in cross examination of the state's witnesses to try to establish additional evidence to satisfy the Meister standard. The court concludes that at this time, defendant's alternate perpetrator proffer is inadmissible under Meister, as it is irrelevant and or excluded by RE 403. IRE. I say that. However, this does not foreclose defendant from cross-examining law enforcement regarding the reasonableness of its investigation and its follow-up on plausible leads. Standard. Trial courts have broad discretion in the admission of evidence at trial. This is you guys hear thing? Oh my god, I can't even think of the words. Anyway, so trial courts have broad discretion in the admission of evidence at trial. Carlson versus Harris. A trial court acts within the bounds of its discretion when it correctly perceived the issue as one of discretion, acted within the outer boundaries of its discretion, acted consistently with the legal standards applicable to the specific choices available to it, reached its decision by the exercise of reason. That's the standard. In analysis, the seminal Idaho case on the admissibility of alternate perpetrator evidence is Meister supra prior to Maestro. Can I make this one more bigger? Is it gonna? Oh yeah, I can. Cool. Prior to Meister, a defendant wishing to present such evidence at trial had to first present proof of connection with the crime, such a train of facts or circumstances as tend clearly to point out someone besides the accused as the guilty party. Remote acts, disconnected and outside of the crime itself, cannot be separately proved for such purpose. State versus Larson. Meister clarified that the Idaho rules of evidence, rather than the more not onerous. I don't know how to say that either. Sorry. God, that is distracting me when it's a song you know. Oh, dude, they've been playing all day. I hope they don't go all night. Just because I wanted to do some editing, and if I do pre-records, they really do show. It's weird. Lives don't pick up as much, but when you do pre-records, it does for some reason. The mic like works different in lives. I don't know why. What am I at? Control alternate perpetrator evidence admissibility. So that, oh, wait, the Larson standard. So they're saying the Meister clarified that there are Idaho rules of evidence rather than the Larson standard. Control alternative perpetrator evidence admissibility. Under these rules, evidence is relevant if it has any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. Idaho Rule of Evidence 403 governs the exclusion of relevant evidence and permits a court to exclude evidence if it's probative value is substantially outweighed by a danger of unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. So they got to kind of weigh that out. Okay. Um, Meister further offered the following guidance on applying these rules and determining whether proffered alternative perpetrator evidence is relevant and admissible. If the defendant proffers evidence which merely tends to mislead the jury that another person committed the crime, or the evidence is not relevant because it does not tend to make the defendant's involvement more probable or less probable, then it is within the trial court's discretion to find the evidence inadmissible. Mere inferences that another person could have committed the crime will most likely not be relevant. If relevant, will still be subject to the limitation provisions. Wait, I have to read that again. I read that wrong. Mere inferences that another person could have committed the crime will most likely not be relevant. And if relevant, will still be subject to the limitation provisions. A defendant has no right to present irrelevant evidence, and even if evidence is relevant, it may be excluded in certain cases. The Idaho rules of evidence effectively safeguard against the admission of conjectural inferences. Um, Without the lower courts needing to apply the Larson direct connection doctrine. Okay. Um, I don't know. What does that mean? Conjectural inferences. I'm gonna look that up because conjectural. Keep hitting the wrong letter. Inferences refers to forming a conclusion based on incomplete or uncertain evidence, essentially an educated guess. It involves theorizing or predicting something without having all the effects, relying instead on a degree of guesswork. Okay. It says, unlike inferences drawn from solid evidence, conjectural inferences are made when some facts are unknown or unclear. It involves a degree of guesswork. Okay. Okay. So, okay. So that's good. Okay. So here the evidence defendant has offered purporting to establish the four individuals as alternative perpetrators abjectly fails to meet the Meister standard. Oh, let me get you guys back up. Hold on a second. There we go. Um, Namely, the evidence is entirely irrelevant. Nothing links these individuals to the homicides or otherwise gives rise to a reasonable inference that they committed the crime. Indeed, it would take nothing short of a rank speculation by the jury to make such a finding. Oh, okay. I want to take a vote though here. How many people, you know what? Hold on. I'm doing a poll. I got to know this. Okay, hold on. I got to pull my YouTube up. Hold on. I want to start the poll real quick because I want to know, get as many people to vote. Hold on. Give me 1 second and then I'll finish. I just thought of this because now I'm just kind of curious because I know there are some people that think he's innocent. So I just want to see what we're working with here in my chat. Okay, so let's do um is, I'll put Brian, oh, I put Brian Kohberger, Berber. Burger is, Kohberger is, we'll put guilty, innocent. What do you want me to put for the middle? Like one other option. Guilty, innocent, or uh I should put an option where he's not the only one that you think he worked with someone. Worked with somebody else. How should I word that, guys? Has an accomplice. Thank you, Sophie. Good one. Has an accomplice. I couldn't think how to word that. You are awesome. Okay. There you go. Let's see. No right or wrong answer. And I like the poll because then it's anonymous. So if people do like think one way or another and they just don't, they're kind of scared to admit it. With this, it's anonymous. So we will get a freaking honest opinion from you guys. Thank you. All right. I'll check it when I'm done reading this. Okay. So it says 3 of the individuals. Let me see what that note is though, too. Where is it? Hold on. Where's number 2? Oh, it's redacted. The footnote. Dang it. Okay. 3 of the individuals were each socially connected to one or more of the victims. So they're saying 3. So they have 4 possible alternative perpetrators, the defense, right? So they're saying 3 of those were each socially connected to one or more of the victims, interacted with one or more of the victims at social events in the hours prior to the homicide. And redact. But I am going to go back and read the footnotes on this one. Oh, no, these were all footnotes right here. Okay. Lived within walking distance of the crime scene and were familiar with the layout of the victim's home from prior social events. While perhaps this evidence could suggest an opportunity to commit the crime, which no doubt is an opportunity shared by dozens of others in the victim's social circles, there is no compelling evidence that any of them had a motive to kill the victims, much less physically harm them or a means to do so. Further, there is no evidence connecting them to the crime scene. They have each cooperated with law enforcement, providing DNA samples, fingerprints, and allowing searches as requested. Notably, lab testing has excluded their DNA from samples taken from the crime scene and victims. The 4th individual did not know the victims, but had a passing connection to one of them while noticing her shopping at a store approximately 5 weeks prior to the homicides. He followed her briefly out the exit of the store while considering approaching her to talk. He turned away before ever speaking to her. The event was captured on a surveillance camera. This individual subsequently cooperated with law enforcement, providing his phone number and a DNA sample. As with the other alleged alternative perpetrators, lab reports excluded his DNA from the samples taken from the crime scene and the victims, and there is no evidence connecting him to the crime scene. And these are footnotes that are redacted. So what do you guys think about that? Let me take a sip of this. Isn't it? That's interesting. So we kind of got a hint of some of the, maybe some idea or, what their alternate perpetrators. Question though, maybe somebody can answer this because I follow this case, of course, but maybe not as like recently as in depth as I am gonna get to though, when we are getting close before the trial, huh? Um, but those DNA, remember there was other DNA that they found? So I know they weren't able to identify anybody from them, right? Were they? But when they say that they compared it and it wasn't the DNA, so that does mean though that it wasn't these guys. These 4 guys weren't the DNA, right? Because they did go as far as to exclude them from the DNA they got, right, or no? I'm just curious. Um, where are we at? In other words, it's not sufficient merely. Where are we at? I forget where I just left off. I guess we just look right here, right? Collectively, defendants proffer with regard to these 4 individuals fails to give rise to even an inference that they committed the crimes, or otherwise make it more or less likely that the defendant was the perpetrator. Therefore, it is irrelevant under IRE 401. I want to see what you guys are saying. I'm the only one who should be sleeping much later here in Europe. What time is it there in Europe? Sophie's choice? Wait, what are you guys talking about? Are you guys even talking about the case? I don't think you are, huh? Huh. Um, okay, let me continue here. Um, defendant has provided no probative, admissible, significant evidence of motive, ill feelings, means, presence at the scene, or any other connection to the crime that could possibly move the ball to the extent it supports an alternate perpetrator theory. At best, defendant's offer of proof can give rise to only wild speculation that it is possible any one of these 4 individuals could have committed the crimes, which is inadequate under Meister. Of proof can give rise to only wild speculation is yeah, so it's inadequate under Meister. Again, mere inferences that another person could have committed the crime will most likely not be relevant. So mere okay. Meister, Idaho, blah, blah. Okay. In other words, it is not sufficient for a defendant to merely offer up unsupported speculation that another person may have committed the crime, which is all defendant has done here. Even if there was a shred of probative value in the proffered evidence beyond wild speculation, it is excluded by IRE 403, as the 10th Circuit noted regarding alternate perpetrator evidence. It is not sufficient for a defendant merely to offer up unsupported speculation that another person may have done the crime. Such speculative blaming intensifies the grave risk of jury confusion, and it invites the jury to render its findings based on emotion or prejudice. Likewise, here, presentation of the proffered alternate perpetrator evidence would pose a great threat of confusing the issue because it would force the state to defend against a nebulous allegation that perhaps these individuals were involved. Yeah, that I mean, this foray would lead the jury astray. turning its focus away from whether the defendant, the only person whose actions are on trial, committed the charged crimes. It also presents a threat of unfair prejudice, as it would invite the jury to blame unrepresented persons for a heinous crime when there is not a scintilla of competent evidence connecting them to the crime. Finally, it would do nothing more than waste the precious time of the jury and the court in what is already a scheduled 3-month trial. Nonetheless, the court's ruling does not preclude defendant from confronting and cross-examining the state's law enforcement witnesses regarding the thoroughness of the investigation, particularly in following up on and ruling out leads. On following up on and ruling out leads generally. Wait, what was that? Defendant cross-examine the state's law enforcement witnessing regarding the thoroughness of the investigation, particularly the following up on and ruling out leads generally. Indeed, the Idaho Court of Appeals recently found in an unpublished opinion that questioning a detective about failing to follow up on other plausible leads was relevant to an alternative perpetrator analysis. Unpublished opinion that questioning a detective about failing to saying question him to failing to follow up on other plausible leads was relevant to alternative perpetrator analysis. We agree with Emerson that a relevant line of inquiry would be to question the scope and breadth of the investigation and to explore on cross-examination whether plausible investigative leads about third parties were ignored or overlooked. It's getting hot, guys, but I'm going to try to make it one more page and then I'll turn on the air. It further stated that this line of questioning may not include inquiries about the investigation of specific third parties absent satisfying Meister noting. I got to read that again. Hold on. It's further stated that this line of questioning may not include inquiries about the investigation of specific third parties absent satisfying Meister. Okay. While evidence challenging the thoroughness and reliability of the investigation might be probative, questioning whether law enforcement investigated specific individuals with no connection to the murder provided no probative evidence. Moreover, with no connection between the evidence and the crime, there is no explanation or justification for the questioning, and it would not help the jury answer the question in the case whether Emerson killed James. The court will apply these same parameters at trial regarding defendant's cross-exam of the law enforcement. He may inquire as to the reasonableness of the investigation, including investigating and ruling out other leads. He is not, however, permitted to question law enforcement about the investigation of any specific individuals as a potential alternate perpetrator without first raising the matter with the court outside the jury's presence. Order. Based on the foregoing defendant's offer of proof, alternate perpetrators is denied. Okay. What do you guys think? All right, let me turn this on real quick. Bring me some air. I'm gonna turn on. Bring me some air. Thank you. That feels good. Okay. So let me move this over here. Let me Move you guys over here. What do you got? I'll think. Let's see what the poll's saying so far. So we have only 23 votes. So 61% guilty, 13 innocent, and 26 had an accomplice. We need more votes. Come on, guys. Let's get more people. Excuse me. I'm drinking this. My water. Because I can't do the coffee with just decaf, but I don't have that much decaf left. I'll need to order some. Anyway, let me say hi to a couple people and then yes, I did. Hey, wait, real quick though. Did you guys see this will be a little wind down material. Did you guys see Bev's people somebody spotted her at the airport and they asked if it was her. She said that I think it was her. I'm thinking she was lying. She said no, that she was Bev's sister. She claimed that she was her sister. So the judge for Karen Reed is who I'm talking about. Oh my God. So they took a picture. How many have seen it? Put a 1 if you've seen it and a 2 if not. Yes, it's sparkling ice, Kim C. Yeah, put a 1 if you've seen the picture of Bev at the airport and 2 if not. Real quick before I show you. And then remind me to show you that. But at first, let's just finish talking about Brian Kohberger. So let's talk about the 4 suspect thing. What do you guys make out of that? So like I said, I don't watch other for the most part, like other creators like me or whatever. And I know a lot of you guys do. So maybe you've seen something. That person, well, no, I don't want you to give any names if you know names because this guy is probably completely innocent. And then if his name gets out there even more, I don't want to be the one to put his name out there. And then, some people will always wonder and suspect him, I feel like. But just answer a yes, no. Don't put any names, okay? But has anybody talked about that person and do they know who he is? Some of these other people that are been like covering this case and all the people involved in the case. The guy that supposedly saw one of the victims from Idaho 4 in wow, 2, you guys haven't seen it? Yay! Hold on, I'll show you in a minute, guys. I'm gonna finish this discussion real quick. Oh, I just got sidetracked. See how easy my brain. Oh yeah, the guy that saw her in the store kind of followed her, wanted to approach her, wanted to talk to her, didn't get the guts to do it, and then kind of like followed her out of the store, not like around, but like followed her to I think out of the exit. I don't think he actually followed her like out of the store, but like you know what I'm saying? It's not like he followed her around after she left the store, but he followed her kind of maybe around the exit. I forget how they worded it. Shoot, hold on, let me see. How did they word it? And then just that was it. But they caught him on surveillance. So I'm wondering if like the defense, I mean, they were just going through all kinds of surveillance, I guess, maybe. So that's one of their suspects, their alternate suspect or what perpetrator, right? Well, let me see how they worded it real quick. Person could have committed, where's it at? 4th individual. Oh, here it is. Hold on, let me just show you. Let's just go over it one more time. Does anybody, my question though was, have you seen anybody talk about this before? Like, was this known by other creators? I know publicly wasn't known by like, it wasn't out there, I don't think big. So it was new to a lot of us, but I know there's some, creators that are just really in this case that are going through all the people, and a lot of the creators I'm talking about think he's innocent, and they're going through like people from the college and suspecting all these other people, right? Did anybody mention this? Did they know? I mean, I don't know how they would have known, but maybe it was out somewhere, or is this like totally new? Oh, I know. I know. I don't think it's true. But you know how people are ex-random, regardless of that, there are still going to be people that will suspect him, that think Brian's innocent, and that think, because a lot of people think Brian's innocent, think, oh, there was mishandling of evidence and he was framed or this or that. So my point is I'm right with you. I think he's guilty, and I think he's been excluded. The DNA, they said it, but there's still people that will have excuses of why, that nope, nope, there's still a chance there's something fishy, because what if the evidence, or what if whatever, it was something corrupt, or they just said it was excluded, or whatever. You know what I'm saying? You know how some people, they're just, it's like confirmation bias type thing. They will see, I don't know, they won't see anything else but what they think. So even if it's like, no, look, the DNA, it's, and they'll have excuses. So my point is, like, I don't want to be one to put out his name if it is known. I'm just curious if anybody has ever talked about it before this. That's all. Okay. Yeah, okay. Okay. So, but yeah, no, I know they did say it was he was excluded. Yep. And I mean, well, let me, this is what it, hold on, right here. This is how they worded it. They said the fourth individual had a passing connection to one of the them while noticing her shopping at a store approximately 5 weeks prior to the homicide. He followed her briefly out to the exit of the store, while considered approaching her to talk. He turned away before ever speaking to her. It was captured on surveillance. So, so yeah, you guys answer my question. So nobody has heard it before. Okay. So they're going to be jumping all over this. The people that think he's innocent, which everybody's allowed to have their own opinion. We have some people think he's innocent in my stream. That's fine. But some of the creators that really are going for his innocence, this is kind of afraid of this, but I feel like they're somehow going to be able to track this guy down, who he is, and they're going to release his name, and maybe the other three, and then these people, it'll follow them around the rest of their life, because there are still thousands, I would say, of people that think he's innocent. There's a big group of people that do think he's innocent. There's some big creators that have following for this case that swear he's innocent, right? So you will have, and even people that think he's guilty, I feel like people will still have that, like, but what if? And like, if these names get out, like, if they know and they're local and they come across them or know them, they're still going to always like have this, like, maybe like wondering type thing. Or maybe not some people that, that think Brian's guilty. I wouldn't say all the people, but the people that think Brian's innocent, or the people that have doubts if he's innocent or not. Or like I said, even people that maybe not 100% that he's innocent or guilty. So it's just, I don't know. I feel like it's not good, because people will always kind of wonder, I feel like, of these people if the names get out. So I hope they don't. And I'm glad that the judge said no, because that would be bad. Because if they got out at trial or something, they would be looked at as murderers for the rest of their lives by some people. When, like, the three are just their friends probably, and then this guy, he probably maybe had a crush on maybe her and one of the girls, and or just wanted to be her friend, or who knows, but was wanting to talk to her for some reason, and just chickened out. It happens, and they talked to him. He offered his DNA, he offered everything. They weren't hiding anything. So, I mean, you guys know my opinion, but does anybody else think? And nobody attack anybody, you guys, in chat or anything. If some different opinion is fine, please let them, because I want to have a discussion. I want people to feel comfortable talking whatever they believe in. So does anybody in here think they have something here with these 4 people. I mean, obviously, it's not gonna be allowed in court, which, thank God, in my opinion, I'm glad. Um, what case are you talking about? Proberger? Okay, yeah. Yeah, Hope G, I know. I know who you're talking about. I don't know. I think it's like one of those things where people like it's like sometimes I feel like it's gotten this thing where it's this thing now, like with like for instance Karen Reed, where it's like almost like it feels like you're fighting for a cause. Like if you're like free this innocent man and let's fight for it, and it's like it's almost like I think when these creators get into a real strong on like what they believe guilt or innocent, I feel like sometimes there's certain people that have trouble then if even if something becomes public where they like normally they would change their mind and be like, oh my God, wait, is he guilty? That they don't, because now they've portrayed it publicly. They built a lot of people following him for a certain like a case, for instance, with their opinion being that, and like, yes, you know what I'm saying? And then also admitting that you're wrong, even though it wouldn't be necessarily like being wrong, it's just your opinion. And I don't know, some people have trouble with that. With like they say something publicly as a creator over and over that they have trouble saying, "Oh, you know what? I think I was wrong. I changed my mind." So they just go harder and harder that way. Or sometimes I feel like it's like more like also they don't even realize I feel like sometimes they don't even realize they're doing it. Depends how. I mean, there's different people doing it for that are caught up in different ways, I feel like. And then some people might honestly just believe it he's innocent. Um, but I think for the most part, I don't know. I don't know. It's tricky. I can't wait for the trial because now that we see, like, are we going to be able to hear those jail calls and letters and interviews? I'm more interested in the more current stuff rather than like his fourth grade teacher. I don't really care. Like, that's, or you know what I'm saying? I want to hear like his newer interviews. Even I would love to hear what his parents think about him. Um, and his sister or brother, like their take on him. Um, but as far as like their history, I mean, I guess like mental health history. Uh, what did they say? Better, like some of the stuff. It's like, wow, they are really going in depth. But I mean, he's got a good lawyer. He really does. I mean, because I feel like for what it is, like she's creating doubt for in a lot of people's mind, not mine, but I feel like she's doing her job. She is. She's good. We'll see her in action when the trial starts, though. Yeah. I was running train did the trial. Oh, I don't know if you're talking about what I've talked about that before. The channels that are covering Diddy, these big channels that have millions of views making up lies. Yeah, there's a lot of them. And I've caught where there's some that I think have multiple channels because it's the same voice and the same story, but they're putting it out multiple different channels. They need to be banned because, like, my mom, I had talked about this a couple times. My mom, like, this was like a few weeks ago, she would say, like, oh, did you hear this, or something, like Justin Bieber spoke at the trial or something. Like, no, he didn't. Where did you see that? She showed me because she's just seeing, like, reading titles of stuff of it and sometimes clicking on it thinking it's true. It's all lies. It's all freaking lies. And then some of them are quoting that one guy that's in the trial was giving, like, a word for word. He was breaking it down. Everybody was like, he was well known for the trial because he would go in and, like, tweet out, like, like live stuff of what was happening. So couple channels were quoting him saying, oh, this is from him and what he said. So they were using a real person who's credible saying that this is what he said. It was all lies, all freaking lies. But there's multiple channels doing it. There was stuff that they did it in Johnny Depp trial. This one, I feel like there's more though, but the Johnny Depp trial had a lot too. Is that what you're talking about, Hope? It's crazy. He actually even talked about it on an interview. That guy, I forget his name, but he even said, no, I think he made a post where he said something like, somebody's pretending to use my stuff. That's not me. It's not accurate. If I was him, I'd sue them or something because it's using his name and doing lies. Talking about, like, Usher, oh, Usher's testified and this person testified and this person did, this person said this, and go out straight up lie. And the craziest things is I would go in the comments. I haven't been to those channels, and they used to pop up when I was watching more Diddy stuff, and it would annoy the crap out of me. So I would go in and just see comments to see if people were calling him out. There'd be a few people calling him out. But this was, like I said, weeks ago. So maybe by now everybody is mad and hearing about, maybe there's more. But like a few weeks ago, there was way more people saying, like, oh, bless Usher's mom's heart. And Usher did the right thing and testified. Oh, what a good thing. Oh, Justin Bieber, good job, Justin Bieber, thinking it's legit. I commented under some. I said, this is a lie. This is a lie. Like, don't believe it. This didn't happen. There's a few people correcting it, but there was more people thinking it was true. So if there's people like that aren't like huge true crime people like us that go to the sources that are like legit reading transcripts and knowing like who to trust in true crime, and they're just seeing, and they get millions of views. So they're very heavily recommended. They were popping up on my channel a bunch, popping up on my mom's. So people will think it's real. They will. They'll think it's real. They'll do like transcripts from the trial, pretending like, acting like this is exactly what happened. But legally, the reason why they're protected, if you go in their description, they say something like a disclaimer saying, like, for entertainment. I don't know. There's like a little key sentence that nobody would probably pick up on because a lot of people don't read through the freaking description. If they do, they wouldn't catch it because they think it's true. They would just think it's a just disclaimer. But I went in there to see, like, if what are they going to say in the description? And there's like one sentence that kind of like would protect them in a way. But YouTube needs to ban them, this bull crap, because that's against policy. Like you're not allowed to clickbait, but that's more than clickbait. Like, you're technically not allowed. That goes against policy. If your thumbnail or title says something that's not true, it's not in your video. But they're a little bit more lenient on that. But if then you click on the video and the whole video is a lie. But I think because of that disclaimer in the descriptions that they could get away with it. It makes me sick though. That millions of views, people are freaking viewing it, thinking it's real. Then they're probably telling their friends, and and this stuff spreading. Oh, Justin Bieber testified against Puff Daddy. Oh, Usher testified. Oh, this person did. Oh, Puff Daddy got up and cried in front of everybody and all this, just like I forget some of the crazy stuff. Yeah, I hate it. I hate it. It's so bullcrap. Now you have it all the time for everything basically, but there's certain things that they have tons of it for. Like I said, Johnny Depp trial, same thing. This one, I'm noticing more channels on the Puff Daddy, like different channels doing it. But Johnny Depp, there's a few big ones, like a million or so views is probably the same ones. Talking about like, oh, uh, they'd be like something like Amber Heard fires her attorney. Johnny Depp causes a huge scene. Just like such outrageous things that if you thought you didn't know any better, it would make, that's why everybody's click on it, because it's like, whoa, that happened. Let me click on it. Yeah. I don't even remember their names because there's so many of them. It's just bullcrap. It makes me really mad. It really does. I should put don't recommend on them. I haven't got recommended those in like a week or so because I haven't been watching a ton on it, Diddy. But yeah, dang it. Um, and it's AI created. Like the voices, most of them have like the AI voice, so it's not really a person talking, and it's just. And then I can't even believe that they use that. What is that guy's name that I'm talking about? Remember, Long Crime interviewed him. I read his reporting on Cassie, the interviews. Like it was one of my first trial videos I did, or second. Does anybody remember his name? I haven't looked at his Twitter in a while, or X or whatever, but he'd go in there and do live posts of what like people said word for word and stuff. Uh, that's messed up. Like I think he could sue or do something, at least strike. Well, I don't know if he could strike him because he could do something. The ones that are using him and lying and it's not what he said, that he could get those taken down because it's not all that. They're doing other things too, but that's something they did too. But he definitely, because that's like lying about, I don't know what that'd fall under, but I think YouTube, if he reported it, I think YouTube would take those down because I wouldn't want, that's his name now, right? For some of those. And then what if people end up finding out, wait, that didn't happen. That guy lied. And then he gets bad reputation, thinking it's him. Anyway, sorry. Um, you could see how passionate I feel about that. Like that makes me like it's a pet peeve of mine. So bad, so bad. Um, Everybody needs to call him out, but it won't be enough because a lot of those people that are believing it obviously aren't like big true crime fans, because they would end up realizing, because they would be watching other true crime stuff reporting on it, and they would, you know what I'm saying, they would see that it's not true. But so I don't know, it's probably a different kind of a group. What was that noise? Man, that's not like a gun. I know it's fireworks time, but that did not sound like a firework. Anyway, let me show you that video or that picture, and then I'm going to end it. Well, I want to go downstairs, make sure everything's all right. I don't know if should I do the Travis live or do some editing for pre-records. What do you guys think? Would you guys be interested in a Travis live? I have a couple documents, like not excuse me, not about the case. It's the hiccup version, all saying. All right, hold on. Ah! See, I could tell when it comes on. Look, I did one hiccup, but I might have been able to. Okay, hold on. You know, you know what I need to do is I need to keep a butter knife in a glass. It's up here. So because most of the time I don't feel like going downstairs during my live. So I just try to do it the sucky way that you have to try over and over, when the knife way takes a second and it works every time. Hold on. That didn't help. No, guys, don't leave. I want to show you Bev's picture. You guys, hold on. At the airport, you'll get a kick out of it. Hold on. Sorry, it took me a minute. I just wanted to, excuse me, finish the Kohberger discussion before I moved on. And then, sorry, I got all into the Diddy stuff. Gosh darn it. I don't want to leave and come back. All right, hold on one second, guys. I got to edit out, like, redact, like, because I have a picture of her. Oh, her sister, because she claims it's her sister. So I have a picture of her sister, but I don't want to dox her, so I'm gonna I just want to black out her last name just so you can see the picture. But oh my god, I swear to gosh. Oh, let's just chat for a minute, guys. So write down what you guys are doing on 4th. You guys, if you were following the Karen Reed, you don't want to miss this if you haven't seen the pictures. It's funny. It made me laugh so much. Oh, I swear. I swear. Don't make fun of me. I just want to show you guys these really quick. I just don't want to. Should I mute it? Is it annoying until I get these done? I don't want to be annoying. You know, some people are so sensitive. Okay, I'm ready. Just put that one in there, that one in there, and then. Oh my god, they're loud. Now you know why it's so important that I have that way to get rid of my hiccups every time. Because look how annoying. I get them a lot, and they're so annoying, loud, and a lot. So, and if I'm downstairs or not on live, I always go do it. But since I'm ending my live, I don't want to go down there and make you guys wait. I am going to bring up a butter knife and cup. I'll put it in my drawer right here, so I'll always be hiccup free. Okay. You ready? Okay. Now here's the thing. Oh, there's a video. I need to find the video. I forgot I was gonna look for the video. Hold on. Shoot. Well, the post does say she said she was her sister. I just can't find. I didn't screenshot like when they post the Facebook, and it's all the way over here. So but right here. So it says, oh yeah, here it is. Bev, there's more than this just picture. Hold on. So Bev was spotted at the airport. The girls asked if she was the judge in the Karen Reed case. She said, no, that's my sister. I saw the video in another group, but can't share it. So I gotta find the video for you. So here's a picture. There's more though. So she's on the phone texting. Oh, before she was wretched, she was a spoiled, and so that's just an old picture I just put with the file. That's her. I didn't write that. That was just in the group. I mean, I would have just had the picture. I don't know if that should be put on there. Okay. Says, just saw on TikTok about her voice. Ask Bev differently, and maybe she'll answer the question. When your daughter and her friend find Annie Bev at the airport heading to New Orleans. Now, the reason they have this circle, look at the watch. So she claims she's her sister. She's not her, it's her sister. But look at the watch in the ring. Now look. It's the same one. Here, let's do. Oh, we could do this and then this. So, same watch, same ring. Okay. Now hold on. Look. That's her on the excuse me, on the actual airplane. Okay. And then that's her sister. So let's see. They have the same nose, but it's definitely Bev. It's definitely Bev. Sorry. There's something different. They have the same kind of nose, how it flips up a little bit. Bev's flips up a little bit more, but the eyes are totally different. The placement of the eyes are different. Like her sister has more like, I don't know, they're like this, more like this, and they're like almost like sink down a little bit more. I don't know. And her cheeks are different. Obviously, it's not her sister. She lied. Um, Here, let's do. Here, I'll do. Sorry, guys, I can't hide it. Yeah, there's no way. That's not her sister. Oh my god, I can't. I would go look for the video, but now this hiccups are gonna be okay. So we got this one. That's her sister. This is her with the watch, just to show, right? Let's do the side by side of this one. Yeah. Bevy Bev. That's you. Wait, I can't. Bevy Bev. You can't hide. I don't know. I'm just being silly. Just fun. I would never like go real life, or I'm not saying that. I'm just being silly. I don't think anybody should bother. You know what I'm saying? I mean, I didn't like her her judging. I think it was horrible. Like she was the worst judge I've ever seen. But I don't know her as a person, and I'm not gonna. You know what I'm saying? I'm just saying. I just think it's funny. She's like, no, that's my sister. But ask better. Oh. So she was heading to New Orleans, and she said, one more time, she said, they asked if she was the judge in the Karen Reed. No, that's my sister. Okay, I'm gonna go. Hold on a second. I got to see if I can find this. Give me 1 second. I'm muting it because I know that's got to be annoying. But hold on. Let me just look. Let me try one thing to see if I can find that video. I know I'll be able to find it. I just forgot to look. But if it's gonna take me a while, I'll just play it on the Travis one. But I just want to look at one spot here and see if it's there. Hold on. You know what? I'm gonna look it up on my phone. I found a video, but I don't know if it's not the one, but there's another video of her. Hold on. It's not the one where she talks though. Hold on. Let me save it. Oh my god. I want to see if I can find the one where she talks though. Hold on. Oh my god. It's her. Just you can just see the back of her. Hold on. Okay, hold on. Let me see. I'm gonna send that to me. Okay, let me see if I can find another one where she talks. There's gotta be one where she talks because they said it. Another picture of her. Hold on, guys. I got more. Hold on. Just give me 1 minute. Oh, did you guys write what you guys are doing for 4th of July? I keep missing. Oh, this is it. I found it. Oh. You look so much alike. That's so cool. Oh, you can't really hear it. Hold on. I'm excited. That was easy because I was able to. I redacted the name of the one, and I was able to just look up that name, and it was right there. All right, I sent it to me. Let's watch. It's crazy how I get so excited for the little things. This is fun. Okay. Here we go. So let's watch the first one. Oh my god. I swear to God. The one where they ask if it's her. Okay, here we go. Oh my gosh. Do you see why it sucks? I hate my hiccups. Okay, here we go. You ready? Is this too big? I guess. Okay, ready? Here we go.
Would you look at that?
Hold on. I gotta play them in order. I gotta play the other one first. Sorry. Shoot, I thought I was playing that one first. Hold on. I'm gonna play the first one. That's weird. I pushed the first one. Here it is. Yeah, here it is. Okay. Sorry, guys. All right, here we go. You ready? Here we go.
It's your sister?
Oh my
Are you
gosh.
serious? That's your sister? Yes.
You look so much alike.
That's amazing. That's so cool. I'll tell her.
Okay.
Really?
Yeah.
Oh my god, are you guys twins? No.
Oh,
You guys look really
you look so
alike.
much alike.
Wow,
Yeah.
that's so cool.
Have a good
day.
flight.
That makes me, I wish she would. God, why didn't they film her face? I mean, I know they were secretly recording, but I wish she would have got her face when she was asking so we could see what she like. What was her face? Read the body language, and they don't. God, they cut the face, but it looked like she was still looking on the phone because she was probably. I mean, we know she was lying. That's definitely Bev. So she's lying, probably being like, "Oh shoot," looking down on her phone. We gotta watch it one more time. Thank you, Crystal. Thank you. First super chat. First super chat of the day. Thanks, Crystal Nantes. I appreciate that. Thank you. All right, let's do it one more time.
It's That's your sister? Yes.
Oh
Are
my
you
gosh.
serious? That's your sister? Yes.
You look so much alike.
That's amazing. That's so cool. I'll tell her.
Okay.
Really? Oh
Yeah.
my god, are you guys twins?
No.
You guys look really
You look so
alike.
much alike.
Wow,
Yeah.
that's so cool.
Have a good
day.
flight.
She said, I'll tell her. Is that what she said? Hold on.
It's your sister. It's your sister?
Gosh.
Serious? That's your sister? Yes.
Wait, I didn't even have it up as high as it goes. There we go. Let's do it one more time.
It's your sister? Yes.
Oh
Are
my
you
gosh.
serious? That's your sister? Yes.
You look so much alike.
That's amazing. That's so cool. I'll tell her.
Okay.
Really? Oh
Yeah.
my god, are you guys twins?
No.
You guys look really
You look so
alike.
much alike.
Wow,
Yeah.
that's so cool.
Have a good
day.
flight.
Oh my gosh, she said, I'll tell her. So wait, is there anybody that thinks it's not her? Does everybody in here do we all agree that that's her, or is there people that don't think it's her? And it's fine if you don't. Is there anybody that actually believes that it's her sister? Okay, so we'll watch the other ones now. This is her.
Oh, would you look at that?
Yeah, well,
Would you look at that?
yeah, there's a few more blemishes on the car.
Oh my gosh, just look at it.
The car is not perfect.
Just look at it. Just look at it.
Yeah, well,
What the heck is that? I mean, just get a look at that.
a cop did that.
A cop. Oh, where is he? I'd like to look at him.
Went over and tried to fight it.
Yeah.
He told me we're not required to post warnings here in New Jersey.
Oh, would you look at that? Listen, I got pulled over in Jersey twice for not wearing a seatbelt in the passenger
Oh,
seat.
yeah.
In the passenger
Oh,
seat.
really?
And got a $40
Oh,
ticket.
Yeah.
Oh, would you look at that?
I was saying, I showed you her sister, silly. Were you just here when I
Would
first
you
showed
look at that?
Yeah, there's a few
The
more
pictures?
blemishes on the car.
when I first showed the pictures? I said, here's her real sister. That's what I had to redact her sister's last name. I said, here's her actual sister. And I said, she has kind of the same nose, but Bev's nose is a little bit more turned up. And I said, the eyes are completely different, the way, like the shape and stuff. You know, were you not listening? Actually, I wanted to watch this again and pause it where they catch her face. Hold on. I guess, do they? They don't really. Gosh darn it. I mean, I know it's hard sometimes when you're privately doing it. Okay. Now I have one more, I think. Wait, hold on. Okay, that one I already played. Okay, hold on. Okay, so I have one more. Oh my God. Hold on. I have one more though, guys. Hold on a second. I'm trying to pull it up here. Oh, I was trying to see if that was this. Hold on. Yeah. Yeah. Okay, here we go. There's a couple pictures on this one. Okay, so sidebar Bev. To watch the ring glasses. And I'll show her sister once again for those misbehaving class clowns that aren't listening to The teacher, saying. All right, hold on. Let me bring it up. Okay. So this is her sister. So yes, she really has a sister. I mean, they look like sisters, but their eyes are different. These ones are like farther apart. They're different shape. The way they sit, it's like her cheeks. They like sit in more. Like it's not her. I mean, that's not her. I'm sorry. And like I said, they have. She has the same watch, the same ring. Where's the? Hold on. Look. Look, red nail polish. So red nail. I know the nail polish. I mean, but she has red nail polish on those both. So yeah. I mean, that's a Beverooski. Beverooski. Beva. This is my favorite. I don't know why this one makes me laugh. But look, you can't deny it. You can't deny the truth. Anyway, I thought that was funny. Anyway, I gotta go get my hiccups under control. Let me see what I feel like doing. If I feel like I'm gonna get off here, I'm gonna get the hiccups. I still gotta do a thumbnail though for the Travis. So if I end up feeling like, okay, I'd rather do, the live, then I'll do a live. Or if I was like, oh, I kind of want to just edit, I might edit, but I probably will do the live. So will you guys look for it? I should have had it ready so I could put you right there. Yeah, I should do it. I should. Since I haven't done a live in a couple of days, just come back, guys. I need all the people I could get. I need you 50 back here. You 54 plus more. Bring in your friends. Oh, I wanted to go over real quick though. Like I said, I got the calls. Try to get people in. If I could get like some good views on the Wade calls, then maybe I won't need to be able to get as much help for if I want to order more. So just like help, but I even help share like the other case calls though too, guys. Share them on Facebook, share it on Twitter, share it on whatever else there is. But I did get them. I haven't listened to all of them, but there's eight 15-minute or more phone calls with Rosemary. So I did good because I didn't even have a phone number where I knew for sure that was her phone number at that time period. Because when you do background searches, they'll bring up like, a lot of phone numbers, and like with the way that they charge for files, they're going to charge me for every phone number they have to look, even if it's a wrong one. It sucks. I know it'll make the charge go up. So I did good. I narrowed it down to like researched and narrowed it down to what I thought from different things of what her phone number would be in that time period, and I got it right. So we got 8 15-minute or more phone calls from Rosemary. We got 2 calls with Jeanette. We finally get to hear Jeanette. And then the rest, there's a bunch with Erica. Now, Jen's, there must not be any with Jen's. And Meek, there must not be any with Meek. And there's one more I ordered, that empty files. So they sent the files, right, with the folder with the phone number, and you click on it, folder's empty, folder's empty, folder's empty. And you know that they freaking charged me. You know what I'm saying? It sucks because I don't know what they charge for them to go and look for, every phone number, then to go look to see if there's any calls. Who freaking knows? But so I had like 3 or 4 empty folders, and I'm like, why even give the empty freaking folders? Just tell them, you know what I'm saying? It's ridiculous. So I'm kind of disappointed, but I am surprised that there were so many calls with Rosemary, number one, and number two, that I got, like, the phone number was right, that I got the right phone number that she had that in 2019. So I'm glad that I researched and figured that one out right, because she doesn't give it in the messages. And then Jeanette, I was kind of surprised because I wasn't sure if there'd be any Jeanette calls. I'm like, there might not even be any Jeanette calls, and there was 2, so I'm happy. They're 2 minutes calls. And then, like I said, a bunch of Erica calls. And that's it. So none with Jen's. Like I said, I figured that there might not be, because from reading the text messages, everything I've read so far with the text messages with Jen's, and phone calls with Vivian and Wade, there was nothing that showed that he had talked to him. Everything I read at that moment, he hadn't talked to him yet. You know what I'm saying? Like when he was talking Vivian or whatever in messages, it would show, like, you could tell he hadn't talked to him at that point. But I was just hoping that maybe sometime after, that he ends up at least like one call. I was hoping even if there's just one call with him, it'd be interesting. Let's hear what does Young sound like? But there wasn't even now, here's the thing. Did he try to call him? I don't know. The folders were empty. So I'm not sure if they even, I don't know. Well, I'm glad though, because it probably would have been more if they did attempts. But like on like, some of Rosemary's and Erica's, there was attempts that they didn't pick up, like last time, and you get charged with them. I'd rather not have those, because I feel like you get charged more the more, the more stuff they go through. But the only problem with these ones, guys, though, they don't have the date. There's no dates on these ones, which sucks. Now, even on the other ones, the dates are tricky, because you have to figure it out, because they're in the title in like a tricky way, but I figured it out. That's why I was able to give you the dates the way they do it. It's not like, oh, this on this date. It's like you got to figure it out by the numbers in the title. And it's a little tricky, but I was able to figure it out, and it didn't match, with the text messages. I mean, the system was right that I figured out. But these new ones, they're not. It's like there's no way that they're in it. There's nothing to figure out, so I don't have dates for them, unfortunately. But so it's kind of good news, bad news on certain things. I was hoping at least one phone call from all those people, but I mean, I was doubting that there was going to be one from Jen's, even doubting that Rosemary, that I was going to get the right number for Rosemary, and doubting that Jeanette even talked to him before death row. But so I'm kind of happy. I mean, like I said, I'm kind of disappointed on some, surprised on some. So yeah. So maybe if you guys could help me, promote those too, and promote these too, like help get it out there. That'd be awesome. That helps so much. Oh my God, these hiccups. Okay, so I haven't listened to any of the Erica yet. I hope listened to the Jeanette ones, and then I listened to some of the Rosemary ones, but that's about as far as I got. But so I don't know how they do it. It's not by call. It's just, I think they just decide whatever they want. It's not broken down by call, no. But I mean, each thing they do is costing, but I don't know. They didn't looking at it, they don't break it down every little step. But I mean, they're charging for however many numbers for them to go have to look they were charging to they said to be able to estimate, to give the estimate of price. And then, like I said, however many numbers, like each time they have to look for a number, they're charging for that. So you don't want to like for instance, oh, Rosemary, why didn't you just give all the ones listed? Because that would, everyone, they would potentially probably charge, and it would only be one of those numbers, so I just had to research, and I'm glad I did the research right, and it worked out. And then what was I gonna say? And then as far as the unanswered calls, they charge for those, and I even asked her, and she said, yeah, last time I was like, can you not, I forgot I ordered it, but she's like, yeah, we still have to charge, and like and then however long it takes to go through them. But it's like, it's really easy to figure out that if it's below a certain like megabyte or kilobyte, you know what I'm saying? If it's below a certain time too, chances are it didn't get picked up. So next time, if I order any more, I'm going to ask her like, hey, if it's below this data point, I don't want that, because that's going to mean that they didn't answer. But I feel like they're still going to freaking charge for them to look, to look it up and stuff. But maybe they won't charge for the time it takes to listen to it, whatever they charge for that, because they want to listen to it. But I feel like they would still charge the same. I don't know. But yeah. So like I said, I don't know if it's because for Jen's, for instance, this file's empty. Now, was there no attempts? I bet, because I feel like if there was some, that they would have put them in the file and then charged, like, if there were attempts and he didn't answer right, I feel like to make more money, they would have still downloaded them, put them in the file, act like they have to listen to them. Here's the thing. I bet you they already know that, though. They probably already know that if it's under a certain thing, that the person didn't answer. So how much do you want to bet that they probably don't even listen to that? So they could charge for them listening to how many, like the last batch, like how many, some of them are like 3-minute calls that they don't answer, the person doesn't answer. They could still charge for it because they, we got to still listen to it. But I bet they figured out, like, wait, if it's under this amount, they don't answer. So we don't even need to listen to it to redact anything, because we know they don't answer. So, well, we can still charge her for it. But then I don't think they were going to listen. They're not that stupid. You know what I'm saying? Probably. So they probably just charge and don't listen to those ones. And then, so as far as Jen's, like I said, I don't know if he just didn't call or there was no answer, so they didn't put any in there. But then if that was the case, then why not just not put the ones where there's no answer in the batch of some of the answer? Like, let's say, like with Rosemary, for instance, there's some not answered. Then if they're not putting on answer, why not just keep those out too? So I'm thinking maybe he didn't even try to call Jen's or Meek. Because like I said, the way I feel like they would just put in those non-answered, because then they'd be able to charge more. I could be wrong, but I mean, it makes kind of sense, because Meek, I'm trying to think in the messages, there's a time chunk where he talks a lot to her, I feel like, but I can't remember when. There's a time he talks to her, but it's been a minute since I feel like, read any from her. I don't know what month that is, but yeah. Anyway, there was one more. I can't remember who else I ordered, and I don't feel like bringing up the document. But okay, guys, let's do this. Travis, I'll see you guys in a little bit. I hope. Come back. Bye.